Ladies and gentlemen, I am SidAlpha. On occasion, I end up making an error, and when I do, I like to make certain that error is corrected and the pertinent information reach my viewers. In my previous video regarding the contract dispute between Frogwares and the publisher Nacon over the game The Sinking City, I was missing some crucial information that would help to provide context to the dispute at hand. So I'm making this update video to provide that additional information and context because it would seem that while yes, Nacon did rip the Games Planet version of the game, which does continue to be an attempt at theft in my eyes, I've seen a great many people commenting that the legal components of the previous video were inaccurate, and most likely due to Nacon's statement on their website. However, Frogwares' statements in regards to the current status of the contract appear to be accurate, and I'll do my best to explain why. Because let's face it, attempting to understand legalese through a French to English Google Translate isn't exactly what I would call easy. In the previous video, I discussed the blog post by Frogwares titled How Nacon Cracked and Pirated the Sinking City. Within that, Frogwares provided a great deal of video and picture evidence that showed Nacon hacking, editing, and re-uploading the Games Planet version of the game to Steam. This much is at least admitted to from Nacon's own statement on their website, where they said, despite this blocking situation created exclusively by Frogwares, Nacon has allowed players to access the game on Steam while still expressly indicating the ownership of Frogwares' rights to the game. Frogwares will also receive the royalties generated by Steam sales, which is Nacon admitting that they have attempted to make the game available on Steam, lending credence to the proof that Frogwares submitted from their blog post where they said, since then Nacon has tried to force Frogwares to deliver a new master version of the game through the use of their lawyers. The French justice refused Nacon's demands twice, first in July 2020 and then in October 2020 during an appeal. The final decision on whether Frogwares is obligated to deliver the Steam version that Nacon is demanding is still set to be judged in trial court in the next months or even years. Now, I've seen many people state that this situation with the contract dispute, claiming that the legal claims made by Frogwares were inaccurate. A few people even went so far as to link me this gamesindustry.biz article. However, after reading through the legal documentation, I have to say that this article is basically incorrect in its assertions, where the author James Batchelor wrote, "This is the result of a decision by the Paris Court of Appeal on October 28th, which ruled that by removing the game, Frogwares had terminated its contract in a manifestly unlawful manner." Where within the court document it stated nothing about the removal of the games being the driving factor for the termination of the contract being unlawful. In fact, it's simply that Frogwares' lawyer seems to be somewhat incompetent and used a deficient dispute over monetary and documentation aspects not covered under the contract as a reason for the contract termination. In fact, from these court documents, it would appear that because of these stipulations of the contract dates, along with the Epic Games Store timed exclusivity, Frogwares was under no obligation whatsoever to provide a Steam or DRM version of the game under the Nacon publishing banner. So let's look at those court proceedings, and please bear in mind this is translated through Google from the website doctrine.fr, and of course, as I just mentioned, the gamesindustry.biz article. Let's look at that segment within the court documents. The reasoning behind Frogwares' termination of the contract were based on 4 complaints contained within their formal notice to Nacon. The first, Frogwares required justifications for some payment deductions and an explanation concerning why those reductions took place. The second was a demand to provide justifications for game receipts and sales deferrals. The third was a requirement to provide all monthly and quarterly United States sales reports for PS4 and Xbox game sales, and the fourth was a demand for an explanation as to the Utomic incident and apparently something going on with Epic Games that isn't really clarified. Nacon's counter to these demands within the notice being used as an excuse for terminating the contract was that the grievances demanded things that were not actually covered under the contract and as such could not be used as a reason for contract termination. To which Frogwares responded that Nacon had failed in their essential obligations to justify the monetary deductions from their royalty payments. To this, the transcript shows the relevant clause of the contract that was agreed to in writing within the legal dispute, where the summary court states that this clause does not list the essential obligations that are the cause of the contract termination dispute. Now, it further states, quote, "The contract qualifies only 2 obligations as material obligations or essential obligations in clauses 2.2 and 2.4, which are not in question in the letter of formal notice. which basically means that the essential obligations listed under those two clauses were not used as any of the reasons for the contract termination. The transcript does discuss that Frogwares would have the right to consult Big Ben's documents relating to the sale of the game during working hours and with a minimum of 30 days notice. This is ostensibly in order for Frogwares to attempt to determine if Big Ben must pay the missing amounts if they aren't able to justify the deductions and penalties if the discrepancies exceed 7%. However, again, per the transcript, as Mr. Yees noted in an email of April 10, 2020, in response to the formal notice of March 2020, the contract in no way indicates that Nacon is required to send supporting documents to Frogwares, but only to send statements, which was done by the Nacon company, as evidenced by the documents provided by both parties. The summary judge ruled that the failure of Nacon to provide supporting documents for the deductions did not constitute a breach of contract or essential obligation, the same with the others of the first three complaints. As for the last complaint regarding Utomic and Epic Games, the court stated that this was such a vague thing that it was not susceptible to the 30 days requirement and would only be able to be assessed by the trial judge. Frogwares further claimed that Nacon's failure to pay the royalties due in 5 separate invoices totaling a little over €1,080,000 and subsequent fees justified the termination of the contract, which would be fair as that would be deemed an essential obligation, paying your bills. However, this is an absolute hard fail on the part of Frogwares as those lack of payments were not listed within the formal notice letter, where then the court states, "It follows therefore that the implementation of the termination clause on March 20th, 2020, with effect from April 20th, 2020, for a reason that does not fall within the contractual obligations of the company, Nacon, therefore constitutes a manifestly unlawful disorder." Which basically means you didn't list anything that actually falls under the contract, so you can't terminate the contract that way. Sorry. The transcript also states that Frogwares incorrectly attempted to implement force majeure due to Nacon's lack of payments. A force majeure is essentially where an extraordinary event or a circumstance beyond a party's control, aka an act of God, war, strike, riot, crime, or, epidemic, for example, prevents one or both parties from fulfilling their contractual obligations. Under those circumstances, as the coup was listed as the reason, and being the contract was executed throughout the period of the coup, the implementation of the force majeure clause was not justified in the eyes of the court. Therefore, under the current ruling and until a final judgment is made, the contract has not been legally terminated. Which leads me back to the GamesIndustry.biz article, where they stated the reason the contract termination was unlawful was because of Frogwares removing the game, which isn't true at all. The termination was deemed to be unlawful, but only because Frogwares failed to include the actual breach due to non-payment of over €1 million by Nacon. And this was important for me to point out, because things like the GamesIndustry.biz article and how they incorrectly stated the reasoning lent credence to the public belief that Frogwares' removal of the game was also unlawful, which it actually wasn't. And again, this is just bad lawyering here on both sides, where Nacon asserts that the failure to deliver a DRM-free version and Steam version of the game violates an essential obligation of the contract and is unlawful, and has also requested a precautionary protection measure which would allow them to request and require the DRM and Steam versions of the game to be released. Whereas Frogwares attempts to claim that the commercial court has no jurisdiction to rule over this dispute. However, Frogwares was incorrect because the contract actually contains a clause conferring jurisdiction to the Paris Commercial Court. But it's worth noting that while Nacon has been demanding the DRM-free and Steam versions of the game, the publishers and developers had signed a distribution exclusivity agreement with Epic Games, which prohibits the sale of the game on any other PC platform before June 27th of 2020, and also that a DRM-free version of the game was not part of the contract agreement. To this, the summary judge stated that the interpretation of the contract clauses in question would exceed their authority in terms of this dispute. It also stated that there was no reason to grant Nacon's request for interim relief. So get wrecked, Nacon, you can't demand the Steam version of the game. This is a contract dispute at its absolute core, and as such likely won't see a resolution anytime soon. From the sounds of it, there were clauses within the contract that are very much in dispute where Nacon is continuing to attempt to publish a ripped and potentially illegal version of the game that they have no right to on Steam. And they have attempted to publish the game on Utomic, which Frogwares maintains they exceeded their contractual authority to do so. In addition, no DRM-free version of the game was ever on the table, at least that's what Frogwares asserts. Also, for a great deal of time, Nacon was demanding a Steam version of the game while the contractual obligations to Epic Games through the timed exclusivity prevented it, and would have prevented the game's release on Utomic as well. However, currently it appears that Nacon has no legal right to post the game onto Steam until and unless the contract dispute is resolved and the outcome of that judgment rules in Nacon's favor. Which means that yes, what Nacon has been attempting to do is very likely against the law, or at the very least, a potential breach of contract. I'm also curious if the over €1 million have been paid to Frogwares yet. They did list 5 specific invoices that went unpaid, and that is a lot of money to keep held back. You know, quite frankly, I'm still siding with Frogwares on this one, but I would recommend their lawyer either straighten up and be more careful, or they hire a more competent attorney. Because if they had included that non-payment within their 30 days notice period, they would have actually had grounds for terminating the contract. But they screwed up on that one, and it may end up biting them in the ass as a result. So anyways, I hope this additional information helps provide clarity and context as to why I was siding with Frogwares and why I do not believe that Nacon really has much of a leg to stand on in terms of their attempting to pirate the game and post it on Steam. Let me know what you think down in the comments below. Once again, ladies and gentlemen, I am SidAlpha, and I'll see you next time.